Hello, my name is Sujit Kunan. Welcome you to this tutorial on law relating to wildlife protection in India. Purpose of this module is to provide an understanding on the laws relating to protection of wildlife in India, and we also will discuss the context in which wildlife laws in India has been developed, and including in its historical context, and we will also discuss key issues and challenges, including the role of judiciary in the development of wildlife protection laws in India. The context in which the law relating to wildlife protection in India has been developed, if we look at these things, India contributes significantly to the biological diversity, even at the global level. For example, India is quite known for its rich wildlife diversity, and it's needless to explain the role of wildlife in maintaining the biological ecological balance. Means, if anything affects the wildlife, that can have implications on the overall ecology. So this is the context in which these wildlife laws in India, this is the context in which wildlife laws has been evolved, and that's also the case in India. So the rationale behind wildlife laws in India is mainly the extinction of species. A large number of species has been extincted, or many species are in the verge of extinction in the contemporary context. There are quite a few important reasons why this wildlife, many species are facing extinction. Most important is the habitat destruction. Habitat destruction means, for example, the situation of forest in India. Whatever affects the forest, that can have direct implication upon wildlife also. And another major factor affecting wildlife in India is hunting and also trade in animals. Trading in animals and animal stuff has been a major reason, even at the international level, that affects the overall health of wildlife, and that's also the case in India as well. So what we can see is, these are the major three important reasons probably why the wildlife law in India has been developed, that is habitat destruction, hunting, trading in animals. So what has been the legal responses to address these problems? When we look at a little bit in the historical context, wildlife laws in India is not a new phenomenon. It has been there even, the history of wildlife laws can even date back to pre-colonial era. For example, Emperor Ashoka during the period 296 to 77 BC, there are several edicts during the period of Emperor Ashoka that is directly linked to wildlife protection. For example, some of these edicts are directly related to prohibition of killing of animals. And when we move on to the colonial period, there are more than one laws relating to wildlife protection during the colonial period. For example, Wild Birds Protection Act 1887, and major purpose of this statute was prohibition of possession or as well as sale of certain birds during a particular period. Another major legislation was Wild Birds and Animals Protection Act 1912, and this was later on amended in 1935. This is a landmark legislation in the context that this is the statute or law that perhaps for the first time introduced this idea of sanctuary. Sanctuary in the sense protected areas for conservation of wildlife. And this 1912 Act, Wild Birds and Animals Protection Act 1912, as amended in 1935, it also carried some provisions that prohibits killing of certain animals. And while this has been the pre-colonial as well as the colonial context, the independent India, the major comprehensive legislation was enacted in 1972, that was Wildlife Protection Act. In this module, we will be overwhelmingly focusing on this statute, that is Wildlife Protection Act 1972, its major provisions, its key features, as well as the role of judiciary or the jurisprudence developed upon this statute triggered by the Indian judiciary, especially the Supreme Court of India. Before we get into the substantive aspects of Wildlife Protection Act, let's have a brief outline of what is the constitutional context of wildlife protection in India, whether there is any provision in the Constitution of India that deals with wildlife protection. There are at least a couple of provisions that deal with wildlife protection. For example, I mean in the section on directive principles of state policy, there is Article 48A expressly deals with the duty of the state to protect wildlife. And similarly, in the section on fundamental duties of citizens, Article 51AG, it also talks about duty of all citizens to protect wildlife in India. So to emphasize these provisions, I mean what they ask is a duty from the state as well as from the duty of the state as well as of the citizens to preserve, protect and safeguard wildlife in India. And there is another section, another part of Article 51AG that requires all citizens, or that makes citizens duty bound to have compassion for living creatures. And this provision or this part of Article 51AG can be directly linked to this issue of cruelty to animals, because the word used in Article 51AG is compassion. That means, I mean, compassion towards animals, and that can be interpreted as putting a duty upon citizens not to be cruel towards animals. And there is another section, another provision in the Constitution that is relevant in the context of wildlife is who has the power to enact law on wildlife protection. As you may already know that, I mean, there are certain provisions in the Constitution that divides legislative power between the parliament and the state legislatures. For example, that means there are three lists: union list, state list and concurrent list as provided in the Constitution. All those subject matters enlisted in the union list, the parliament has the exclusive power to make laws. Similarly, all those subject matters in the state list, state legislatures have the exclusive power to make laws. And as far as subject matters in the concurrent list is concerned, both the parliament and the state legislatures have equally the power to enact laws. So in this context, I mean, originally the Constitution had included wildlife in the state list, and this scenario was changed in 1976 through Constitution 42nd Amendment Act, and through this amendment the subject matter wildlife was included in the concurrent list. So the legal implication is, as of now, the situation is both the parliament as well as the state legislatures can enact laws on wildlife protection. But however, as we look at the Wildlife Protection Act, this was enacted in 1972, the amendment was adopted in 1976. So when the Wildlife Protection Act 1972 was adopted, I mean the subject matter wildlife was part of the state list. That means in 1972 it was in the exclusive domain of the state legislatures to enact any law on wildlife protection. However, this 1972 Act is a central legislation. So we will just look at how it was possible for the Parliament to enact Wildlife Protection Act 1972. There is a provision in the Constitution, that's Article 252. According to Article 252, any subject matter which falls within the state list the law can be enacted on those subject matter by the Parliament, provided 2 or more states have passed a resolution to that effect. That means if states are willing, they can concede their power to the parliament, or they can permit the parliament to enact law. This is the context in which, or this is the provision through which the Wildlife Protection Act 1972 was passed by the parliament. And this, after 1972, this had undergone at least 4 or 5 amendments, that is in 1982, 86, 1991, 2002 and 2006. And all these amendments included a number of significant changes to this 1972 Act, and some of them are, for example, originally it was meant only for wild animals. So through these amendments, plants were also included, and originally and these amendments also tried to strengthen the power of the central government as far as this regulation or the protection of wildlife in India is concerned. There is a recent bill that is Wildlife Protection Amendment Bill 2013 is pending before the Parliament. So now let's have a discussion on the substantive aspect of Wildlife Protection Act 1972. What are the major purposes of this Wildlife Protection Act 1972? I mean, the major purpose, as it is clear from the title of the act, is to protect wildlife. And we had already mentioned, or we had already discussed this context in which this act was enacted, because many species were either extincted or in the verge of extinction. So the purpose of the act was to how to curtail or control this wildlife, and how to protect and conserve the existing population, or how to nurture the wildlife population in India. So the major legal measures, I mean, if you look at the substantive part of the Wildlife Protection Act 1972, the major legal measures are: one, prohibition of hunting of wild animals. This is mainly because hunting was considered, or hunting was one of the major reasons why this wildlife population was affected. Second, and the similar provisions are also there as far as these plants are concerned. For example, there are provisions that prohibit uprooting of plants. And the third major substantive measure is protection and management of wildlife habitats, because habitat destruction was one of the major reasons, one of the major threats for wildlife population in India. So Wildlife Protection Act 1972 introduced protection and management of wildlife, the natural habitats of wildlife, and this is mainly in the form of sanctuaries and national parks. And another major the fourth major legal measure is regulation and control of trade in wildlife and parts and products, because this huge lucrative market for wildlife products or wildlife stuff, wildlife trophies, is one of the major reasons why wildlife population is affected. So Wildlife Protection Act 1972 has some provisions that regulates or control or prohibit trade in wildlife. And fifth major legal measure is again, it is related to the protection of wildlife habitat, but through I mean, this is mainly aiming to protect wildlife in captivity. This is mainly by establishing and managing zoos